Oh, you know it's about to get interesting when court starts with a triple hey. This isn't small talk. This is the calm before a legal storm.
Yes. All right, can you come forward, please? All right, so I know that moms have concerns about their children, right? He's been taken to the back. There's banging on the back. He's the only person back there. And so I want you to know nobody has harmed him or hurt him. Your counsel, the counsel for your son, asked for a short break so they can explain to him as far as what's coming in and why it's coming in. But it appears that he doesn't want to hear that. So.
Yes, you heard that right. Punishment can proceed without the defendant in the room. In most US courts, a defendant can waive their right to be present if they're disruptive. But here, that waiver is not exactly voluntary.
This trial is going to continue. Punishment may continue without him. I would hate for him to be brought out, strapped down, which is what will end up happening. Because the deputies don't want to bring him out because things may happen. So that's where we are. And
we are very much looking forward to a vigorous cross as soon as it's our turn.
Mm-hmm. Well,
you get talk to your sentence and help come up and down. That's what I need.
Well, the only thing is I don't know if the deputies would allow you in the back or not. Deputy Mahia, Deputy Laura, is it? All right. So, but he's not going to be released from the cell. Okay, so he's inside the cell, so that this trial can continue. I'll allow you to go back there, but you're going to have to leave your purse and everything out here. You can leave it there. No one will bother it. And yes. State, do you have any objections to her speaking to him?
Absolutely not.
Okay.
Your Honor?
Yes.
I have one other thing I wanted to mention to both the states present at the beginning of the trials. We heard a general motion to eliminate this.
Well, let's take care of this first, and then I'll take care of that. Okay. So if you'll I'll go back there with his mom and the other attorney, please.
Keeping the cuffs on is a big deal. Visible restraints can prejudice a jury, but safety and courtroom order often outweigh that risk. Here, the judge is trying to hide them to avoid bias. Basically, courtroom damage control in real time.
One pair of pants later.
Or Deputy Mahia, do you want to keep the cuffs on? Do you feel that's best for now?
Yes.
All right. So the cuffs are going to remain on for now.
Cover them with the suit department.
Yes.
We think that'd be highly prejudicial. We not the one that's sitting next to him. That's true.
I mean, he just needs to hide the handcuffs, and we'll see how he does. And if he proves that he can remain calm, then the jury won't see him. And
Notice how the judge's denial here isn't just about punishment, it's about precedent. Once a defendant's been disruptive, the court has broad discretion to keep restraints on for safety. It's a chess move in judicial authority.
What we can do is, when the jury comes in, everyone just remains seated. And what I'll tell the jury is everyone is remaining seated because I request that they remain seated. And I'll say something because of the microphones. So that way they won't know.
Your Honor.
Yes.
We request for the record that Mr. Morganfield be uncuffed at this time.
Oh, we can go on the record. All right. You're requesting that he be uncuffed, is that correct?
Yes, Your Honor, due to the prejudicial nature, and he has assured the court that he will be cuffed.
All right, all right, thank you. So that will be denied, and so that the record is clear. Mr. Morganfield became disruptive in the courtroom. The court took a recess at approximately, I believe it was 2:13, and I told the jury that we will be back at 2:20. and I allowed Mr. Morganfield's mother to speak with him. The deputies took Mr. Morganfield back in the holding cells. Mr. Morganfield was banging on the holding cells, being disrupted from the back. Both defense counsel thought that his mother would be able to calm him down. His mother was allowed to go into the back. I could still hear yelling from Mr. Morganfield in the back. And we are here at 2:46. And the reason why we are here at 2:46 is because it took 20 minutes for Mr. Morganfield to come down. So the court will have Mr. Morganfield remain with handcuffs on. If Mr. Morganfield is able to not be disrupted with the handcuffs on, then the court will consider, of course, with input from the deputies who are in charge with security, whether or not they should be removed. Off the record, the court has been informed, both the state and the defense and Mr. Morganfield, that they are to remain seated when the jury comes in, so that the jury will think there is no disrespect to the court or them. The court will instruct the jurors that I have asked both the defense and the state and Mr. Morganfield to remain seated for technical, logical reasons. And for the record, from here, you cannot see that Mr. Morganfield is handcuffed because his shirt is covering the cuffs.
Yeah, he also has leg restraints on, also, which I think the jury will see. And the shirt is not covering the cuffs.
I'm clearly know what I'm doing.
All right, Deputy Mejia and Deputy Laura, with regards to the handcuffs to the legs for courtroom safety, do you believe that those should remain?
Yes.
All right, those will remain. Mr. Morganfield, you will just need to put your legs in between the two legs of the desk.
We put a box underneath it, maybe.
And there it is, the emotional peak. Guilty on count 1, not guilty on counts 2 and 3. Mixed verdicts like this are a roller coaster. Relief for some charges, devastation for others.
You can hide it.
Yes. Yes. And so for the record, the wooden cabinet is being moved in front of Mr. Morganfield's legs, and the jury will not be able to see his legs. It rolls, Mr. Cantrell. No. No. All right, we're going to bring the jurors in. All right, the verdict form appears to be in proper order. If the defendant could be rise, please. Okay, count 1 verdict form reads, we the jury find the defendant, Alexis Morganfield, guilty of the offense of sexual assault of a child as charged in count 1 of the indictment. Count 2 reads, we the jury find the defendant, Alexis Morganfield, not guilty of count 2. Count 3 reads, we the jury find the defendant, Alexis Morganfield, not guilty of count 3.
A little longer than a few minutes later.
Have a direction reflect that it's Alexis Morganfield Jr. Alexis Morganfield Jr. will be on the judges.
Thank you. And that will be reflected in the Bear County computer system as well?
Yes.
Thank you.
All right. Mr. Morganfield? All right. I'm going to impose the jury's verdict, which is for 6 years in the prison. He'll be credit for any time served. There will be Chapter 62 registration. Did you have a chance to review the document entitled Trial Court Certification with your attorneys, and did you understand it?
We did, and he just signed it, Your Honor.
Well, you do have a right to appeal the defense. This is not regarding this the jury trial case. Defense, are you planning on having an appeal, or are you not?
I will not be, Your Honor. And we will take the appropriate next steps within the next day.
And we'll be filing a motion for new trials promptly.
Oh, thank you. This is for your client.
Thank you.
All right, and this actually, we have another case with.
Quick reality check. Prison sentences for serious felonies rarely turn into house arrest, no matter how politely you ask. This is one of those moments where TV courtroom dramas and real life part ways.
Ms. Morganfield, business purposes, if you will.
We didn't read that date, but she did take off tomorrow, so.
But so, you can drop by tomorrow and we'll make sure get you a date or call in to get a date from the other cases.
Yes, ma'am. My client will be addressed.
Yes.
My bad. I get involved in. How long you gotta do?
Okay.
If I'm asked,
Yes.
how long do I gotta do next?
We'll answer that question.
Your attorneys will have to speak to you with regards to role eligibility. I don't have any control of that. My only job is to make sure that you receive all of the appropriate credit, and your attorneys will speak with the clerks to make sure that the appropriate credit is in the system.
Okay, you say you will do that house arrest and it's
No, not for house arrest.
the purpose is we will do.
The law says she can't.
Not for house arrest.
It's it's not good. So when you need you gotta then register.
Under 42017, there's a provision where it may become cancelable in future due to your age. It's not a guarantee. It's a